stuck my hand in it.
I saw you, yeah, I saw you in there, yeah.
And I'm trying to figure out what expensive all that is. No, I could pay.
Yeah, yeah.
The attorneys be ready.
Yes, sir. Yes, sir.
Chancellor Chris Haggerty will be presiding. Please give your attention to the court and thank you. You may be seated. Thank you.
Good afternoon, everyone. For those of you who don't know me, my name is Chris Haggerty. I'm the Chancellor of Part 3 of Knox County Chancellors's Court. We've got one case today, or this afternoon. Number 212611-3. Everyone ready?
Sure.
Any preliminary matters need to be taken out before we have the hearing?
One matter, Your Honor. It's good news, I think, that the parties parties have stipulated to the entry of the declarations that are attached to the motions, to the oppositions, and the authorities that are cited in there. And so our plan is to just proceed with oral argument today.
Okay, so there will be no evidentiary proof whatsoever.
Right, just the papers, Your Honor.
Okay. That being the case, any other stipulations need to be made?
Not that I'm aware of.
All right, well, let's move forward with the motion.
Good afternoon, Your Honor. Cam Norris, here for the plaintiff, Joey Aguilar. May it please the court. This case is narrow. Athletes get 4 full seasons of NCAA eligibility. Joey Aguilar has played 3 full seasons in the NCAA. He wants relief from the JUCO rule so he can play his 4th and final season at Tennessee. 5 courts have given that relief to other JUCO players, and the NCAA gave that relief to this JUCO player just last year. The equities overwhelmingly favor maintaining that status quo for Mr. Aguilar. Now, my friends at the NCAA don't want this case to be narrow. They want it to be about broader issues, but it's not. This case is not about taking spots from other players. Under this court's TRO, Mr. Aguilar is already on the team, and he'll have to win the starting quarterback job, just like everyone has to win the job every year. If he does win it, then he earned it. The result would be exactly the same for the remaining players as if Tennessee had signed a veteran quarterback in the transfer portal, which the NCAA freely allows. This case is also not about how old you should be when you play college football. The NCAA has no rule about age, has no age limit. Chris Winkie was 28 years old when he beat Josh Heupel for the Heisman. And Indiana just won a national championship with a team full of 23-year-olds. And aside from not being the oldest player in D1 next year, Mr. Aguilar won't even be the oldest player on his own team. That would be the punter, Jackson Ross, who is a 27-year-old junior because he played professional rugby before college, which the NCAA also freely allows. And finally, this case is not a policy debate about the future of college football or its current status. Your Honor's decision is not going to increase or decrease the number of lawsuits against the NCAA at all. The NCAA is getting sued a lot right now because it's a monopoly. And the Supreme Court, in a case called Alston in 2021, told them that you are subject to the ordinary antitrust laws. It's not fun to be a monopoly when the antitrust laws apply to you, but that's why you get a lot of lawsuits. But all the courts can do is apply that antitrust law neutrally and faithfully to the NCAA, not warp it to give the NCAA some sort of antitrust exemption that it has never been able to win in the democratic process, or hesitate to grant relief that is deserved because it fears that the NCAA will criticize another state court as being biased. And for those who do think college football has some problems right now, I don't think the answer involves shutting out former JUCO players. Joey Aguilar went from a 0-star recruit to the bench of a junior college to the starting quarterback job at the University of Tennessee. He and other JUCO players like him are inspirational. They embody hard work, perseverance, and the very best parts of the amateurism that the NCAA says that it values. This court should convert its TRO into a temporary injunction. Your Honor, I'd like to proceed first in sort of reverse order. I'll start with the equities and then get to the merits, because I think the equities are fairly simple and overwhelmingly in our favor. Under the Gibson treatise, the equities, when they are so lopsided, that still justifies a temporary injunction, even if the merits are unclear or uncertain. We think that is certainly the case here. In terms of irreparable harm to my client, he faces immediate, irreparable, and multi-million-dollar harm from not being able to play in the 2026 season. I know the NCAA cites a few cases about irreparable harm, but we're the only ones who have submitted evidence from Coach Josh Heupel and from Joey's agent. There's 2 declarations in the record. We're the only ones who have evidence about the harm that he faces, and that evidence is undisputed. Courts don't even really disagree about whether the lost opportunity to play a season of Division I college football is irreparable. They largely agree that it is, almost overwhelmingly. If you look at the Bram decision in the federal courts, the Martinson decision, the Moore decision in Texas, they all recognize this principle and cite a laundry list of cases upholding it. And I think it's pretty common sense. You can ask any former player who ever donned the orange and white what it's worth to them that they got to play a season for Tennessee or another Division I college football program. I think they would tell you that that's a priceless experience. It can't be quantified with damages, which is what makes it irreparable. You can't get it back at the end of final judgment when the season is over. And you've potentially, for my client, have missed out on the opportunity to really prepare and go to the NFL Combine as well. I think I'd be surprised that the NCAA would push back on this. They have lots of public statements where they have touted, of course, the value of college athletics. And their whole argument about how older players are taking opportunities away from younger players implicitly concedes that these opportunities are themselves extremely valuable and hard to put a price tag on. I mentioned the NFL, but that's another part of my client's irreparable harm. Every year, there's a story about a college player who comes back for another season and performs so well on the field that their draft stock with the NFL skyrockets. It happens every year. It happened with Tyler Shugg last year, who was a seventh-year college player, was a backup quarterback for all the teams he ever played on. When he was 25, he got an opportunity with Louisville to be the starting quarterback, and he had a great season. He ends up getting drafted, I think, by the New Orleans Saints and actually seeing the field a couple years later. It happens every year, and you don't get that opportunity to improve your ability to get drafted unless you were on the field playing and showing teams in real game time action your talents. That is real future compensation that my client cannot earn and that no court would be able to reliably calculate through damages looking backwards. And the last harm, it's maybe the most obvious harm, is my client immediately stands to lose between at least $2 to $4 million of NIL compensation for playing at Tennessee in his final season. That, as courts like the Bram court I mentioned before have recognized, is also irreparable. Of course, that is dollars and cents, but your NIL value is not that starting number. Your NIL value is fluid over the course of the season. So if Joey throws 10 touchdowns against Georgia Tech, his NIL value is going to go up in real time. He will get additional offers for additional NIL opportunities that come from performing well on the field. And those will be impossible to recreate after the fact. So that's the harm on our side. The harm on their side, I think it doesn't count because in our view, the JUCO rule is likely illegal anyway, so there's no harm to freezing it temporarily. The public interest overwhelmingly favors enforcing the antitrust laws and having full and free competition and not having monopolies stifle full and free competition. But even if you ignore the merits, I think the harms are still lopsided on our side. And that's because in this particular case, the NCAA did not enforce this exact rule for an entire year against anybody last year. So in 2025, they gave a blanket waiver to all Division I athletes who were otherwise disqualified under the JUCO rule, and they let all of them play. And they didn't even have to do that. They got one injunction from the federal court in Nashville in favor of Diego Pavia. They turned around and chose to waive the JUCO rule for everyone else. So they were willing to live with a season of college football without this rule. I don't think freezing it here for this one particular player for this one particular year could possibly harm them. I mean, I think it's empirically disproven. And it's not like the players who they waived this rule for were nobodies. They were big-time players. Diego Pavia had the waiver after he won a preliminary injunction. He was the runner-up for the Heisman Trophy. Lewis Moore is the player that we cite in the case out of Texas. He's a starting safety for Indiana who won a national championship, and he got to play because the JUCO rule was waived, and he won a TRO from a state court. And of course, my client also benefited from that relief last year from the JUCO rule, and he was the regular season leader in the SEC in terms of passing yards. These were important figures in college football. Meanwhile, while the rule was frozen, college football had its highest number of viewers, highest amount of revenue that it has ever seen. I also, again, back to my opening. Sure.
Was Moore's case in Texas, was it based on their state antitrust statute?
It was, Your Honor. It was. And that's a particularly interesting example because that was a Texas court applying Texas law to benefit a player who wanted to go to Indiana. So I don't, there's been accusations that state courts are biased in their brief. I think that just disproves it. There was no bias there. That was a court faithfully applying the law, as all courts do in these cases.
Have you reviewed that statute, see if it in any way corresponds to our statute?
I have not looked at the Texas statute recently. My understanding is a lot of courts operate in the states on the assumption that our statute is at least as broad as federal law, and so if they find a violation of, equivalent federal law principles, they'll go ahead.
Let's get to the lick law, as it says. Is our statute as broad, or is it broader?
I've never seen a statute as broad as ours,
Nor have I,
and it was amended in 2024 and has not even been interpreted, to my knowledge, by,
as far as I can tell it has.
right. And
But where are we going on that? How are we gonna use old precedent to interpret the new statute? Because I'm a state court judge, what am I supposed to do? Tell me what I'm gonna do, because I'm gonna ask him the same thing.
I think there's two paths forward. Number one is you see the text, you see how broad it is, and you say, well, if this conduct would violate the federal law, then I know it violates our statute too, because ours is broader. So you can make that determination. Or I think look at the text. The text says, our statute is unique in that it says anything that tends to lessen the price of services is covered separately from restraining trade. And so you look at that, and I think you look at the misconduct alleged here by the NCAA and how they're depressing the NIL value of a whole class of athletes, and it just fits right in that text. And so if the federal authorities are not persuasive,
Does it have any effect on interstate commerce?
it has an incidental effect on interstate commerce.
Incidental effect. How can you say that? He's gonna go play. He can't play all of his games at home, can he?
No, Your Honor, but there's nothing that forbids Tennessee from regulating things that have a significant effect in the state of Tennessee, just because they also have a significant effect elsewhere. And the Supreme Court has a case called Pork Producers. It's only 2 years old. That makes this very clear. When California was regulating the pork industry, whatever California does goes nationwide, because the pork producers have to meet the most stringent state standard. The Supreme Court said that is not a problem under the Dormant Commerce Clause.
So under the Dormant Commerce Clause, if our statute says none of these rules apply, then it has an extraterritorial effect, then it has to.
It can, and that's perfectly permissible under the,
It has to, doesn't it?
if it does not, yeah, you're right, if it does not discriminate, if it's neutrally applicable.
What you're doing is you're allowing the state of Tennessee to regulate for the rest of, just for the lack of a better, I'm not gonna say market, because we're gonna be talking about that later, but for the lack of a better group of affected persons for the whole southeastern conference, aren't we? Because he has to play, he plays 6 home games next year, right? 6?
Take your word for it, Your Honor, you have not looked, yeah.
I don't know either. But, he's going to play some home games. But are we going to enforce our law when he goes to Kentucky or to South Carolina? Because I know we're going to South Carolina next year. So do we take our law with us and enforce it out there?
I think that under the pork producers case is perfectly acceptable, that states get to enforce their own laws. If that happens to have an effect outside of the state, that is not a constitutional problem. States are not, on the flip side, the NCAA has no power to disempower the 50 states from.
Let's just use it the other way around. Let's say we're playing, South Carolina, let's use South Carolina, or somebody that's coming into town next year. And they're not using a quarterback because their statute, their NHS statute says is less broad than ours, and pinches down and says you can't do what he's wanting to do. So they come into town and they say, oh, for the purposes of this game, we're using Joe Namath the fourth, and he's playing for us today. Can they do that?
Your Honor, I think each state gets to have its own laws, and if the NCAA is in that state violating that state's laws, that's something they have to deal with until they get a statute from Congress preempting all state laws, which they don't have. And the same was true, Diego Pavia played all over the country. I don't think
And there was a waiver, though, was there not?
well, he wanted an injunction just for himself. And so if they hadn't waived it on their own voluntary choice, he would have had an injunction allowing just him to play all over the country. That was
You're sure of that, there hadn't been a waiver?
unless they had won their appeal, which they did not. They appealed.
They were removed because they didn't go any further, right?
Right,
Okay, so,
right.
all right, go ahead.
But he's one of at least 5 in this exact context who have won injunctions for themselves that allowed them to play.
Correct. The majority of the cases you've sent us.
Yeah. Right, so we're talking about, I think we should go back to maybe the harm to the NCAA in general. I do think, and this is related to Your Honor's point, that the nature of litigation is, and by statute in Tennessee, you can't have a class action under the antitrust laws. You have to go one by one. And so the relief here that Your Honor enters, the only relief we've asked for is for Mr. Aguilar to be able to play in 2026. That does not harm the NCAA to have one player more playing football, the same player who was violating, according to them, the same rule last year, and they voluntarily chose to let play all year. That is not a harm to them. And the NCAA's JUCO rule, it's not going to go anywhere if Your Honor enters an injunction. You don't have the power to wipe it off the books. They will have lost one case in one court under one state's law. That is not some sort of catastrophic carry-on effect. I think they are concerned that Your Honor's opinion doing so would be persuasive to other courts, but the persuasive value of an opinion is not an irreparable harm to the recipient of it on the other side. And I think the only other harm that's been identified, and I don't want to discount this too much and take it seriously, though, is that someone else's spot might be lost if Mr. Aguilar gets an injunction. That is not the case. He's currently on the team. There's been some reference to roster limits. My understanding is the House settlement imposed some roster limits, but then at the last minute, those were largely erased. And so there are actually no real roster limits. There are walk-ons available. My understanding is also that every year there's...
Before you just gloss over that, how do we ascertain? We stipulated almost everything, but I want to know what that number is. What is it? Do you know? Can you ascertain that? Do you? Thank you.
Yeah, and the roster limit, I believe, is 105, but this House settlement allows them to extend beyond that, maybe an additional 10 or 20 players that are beyond the roster limit. And the nature of college football, there's just every year people get hurt, people get in disciplinary trouble, people decide, I don't like practice anymore, I'm done playing football. There's turnover all the time, so there's always spots for that last person. He's not taking anybody's spot. The Bram decision that we cite out of this federal court decision actually gets into this and says, at least in that case, the NCAA conceded that there are no real roster limits anymore. So there's not this one-for-one trade-off. And with that, I think I'll transition to the merits unless Your Honor has any questions about the equities.
Go ahead. I've got several questions that I'm going to ask you.
Great, and it's all related. The likelihood of success under our state's antitrust law. As I've mentioned, and Your Honor's read, there are at least four courts who agree with us that this exact same rule violates federal law, which, if that's true, then there certainly is no Dormant Commerce Clause problem if the same conduct violates federal law anyway. But that is what several courts have held. But as we've discussed, if Your Honor has any doubts about that, Tennessee's law is wholly broader, especially as amended in 2024. Before 2024, the state Supreme Court has a decision called Freeman that points out that already before 2024, we were broader than federal law in some senses. And it says we're one of the few states that does not have a clause in our statute that says this should mirror federal law, which makes our law broader. You could look at the text if you wanted to know if our law is broader also. It says, it's not written like the Sherman Act. It says that anything that tends to lessen competition or is intended to lessen competition or that tends to affect prices, all of that is covered by our statute. And then I think one thing we haven't talked about is...
So let me just focus on the breadth of our statute. This is the broadest. I've read almost 100 cases involving this type of thing, not just Sherman Act cases, but I'll call them baby Sherman Act cases. This is the broadest one I've ever seen. Would you agree with me on that?
As far as I'm aware, yes.
Would you agree, counsel? All right, go ahead.
Yes, and I'm going to make it a little bit broader because it's right side by side of these 2024 amendments to our statute. The Tennessee legislature passes another NIL statute, which is updated then in 2025. And I think you have to read these statutes together because the NIL statute says that no athletic conference, in state or out of state, it doesn't discriminate, but no athletic conference, which would include the NCAA, is allowed under Tennessee law to restrict the NIL compensation of student athletes. So it recognizes this market. It declares restrictions on this compensation to be illegal, and then it ties that restriction to our state antitrust law and says you cannot violate that either.
It says on its face, though, on its face, that law says no federal law or anything can violate our law. Is that what it says?
No private athletic association can violate our law by restricting NIL compensation, correct?
Is that, there's some cases that would say that that's per se violent of the clause.
Of the Commerce Clause, Your Honor? I think there are maybe some cases that suggest that. I think the pork producers case from 2023 overrules a lot of those cases.
I don't, well, that's an argument you can make, but I'm not sure that it's correct. But if you wanted me to read those two, do you really want me to read those two statutes together?
I think so, Your Honor. I think it is perfectly constitutional.
No,
And
I'm just asking you, do you want me to?
I think they are rightly read together. I don't think we have to have you read them together to win. So I think we can win on Tennessee is no broader than federal law.
It's your suggestion that I read them together because that's what you want in furtherance of your case.
That is our first position, Your Honor, yes. And the alternative, the easier route potentially, is just to say, I'll assume it's no broader than federal law. That gets rid of all the constitutional concerns. This violates federal law as well, as several courts have held. But that, I do think the NIL statute is informative. It literally cites our antitrust statute in it. But I'll just take on federal law here for a minute. Federal law, I think we all agree, like sort of
Let
the,
me ask you a question. Did you research the modification to the TT, the trust statute?
we did.
And do you have a copy of like the bill, the sponsors on it and all the markups and everything like that? Do you have that available to the court?
Not today, Your Honor. I looked at that in researching and putting together our briefs. We looked at
Okay, if the council doesn't mind, could he supply that to me?
Of course, that's good.
I'd like you to do that.
Yes, Your Honor. And my summary of it is, when I reviewed it, was that it's clear that this was intended to broaden our statute from where it was before. That our statute had been interpreted too, maybe correctly, but too narrowly. They wanted to cover the ambit of antitrust problems. And that's why they amended it. And I do think it's telling that they amended it in the same session as they passed a new NIL statute.
I don't disagree with you. I'm just asking you whether you want me to interpret them together, and I'm going to now.
Yeah. I do, Your Honor. I'm really not worried about the constitutional problem after the pork producers case. It's very clear that there used to be this concern about extraterritorial applications of laws. California used to be a big culprit of this because when they regulate something, their economy is so large, it has spillover effects. Supreme Court, 5 justices said that it's not a violation of the Constitution. But let's just go to the floor here of what I could win by proving, which is the rule of reason under federal law, using that as an analogy. The 4 courts, you got this Texas state court in the Moore case as well that I think is following federal analogs. So 4 to 5 courts, depending on how you count, have held that the JUCO rule violates what's called a quick look rule of reason analysis.
And that's what the judge did up in Greenville. He said, I'm not going to use this quick look to make a decision. I think it did be fleshed out more. Did he say that? Judge Ashley?
That was Judge Ashley, yes. I also had a case in front of Judge Corker against my friend, Mr. Askew, where he did the opposite. Different rule, but I think courts have gone different ways. We're not denying that on this issue, which is why I do think that our statute being broader is probably could be relevant to your decision. But under that analysis, we identify anti-competitive effects. They justify them with pro-competitive reasons, and then we identify alternatives. And I think the more persuasive of the cases go our way on this, because the JUCO rule is anti-competitive on its face. I think it is indisputable that the NCAA has a monopoly on Division I football. So all Division I schools are members of the NCAA. They get together and they pass rules that constrain each other, which is what economists call horizontal restraint on trade. And with this one, the JUCO rule, there is a class of athletes now who are no longer eligible to participate on their teams. And that causes 2 major kinds of harms. There's what they call the labor market harm, which is the player side, and then the consumer market, which is the fan side, the people watching the sport. And I think there's just kind of 2 simple ways to understand this. And it's what Justice Kavanaugh said in the Alston case. He said, if the NCAA if any other industry was doing what the NCAA does on a daily basis, it would be plainly illegal, flatly illegal, he said, under the antitrust laws. And so I gave the example in the brief. I think it's a good example. if McDonald's, Wendy's, Burger King, Arby's, Taco Bell, all the fast food chains got together, created an association, and they said, we are only going to hire people to work at our restaurants for 4 years, and then they got to go. And we're going to hire them right out of high school. So 18, 19, 20, 21, they got to get out of here. That would be laughed out of court under the antitrust laws if they did that, because that is an obvious scheme to depress the wages of those workers by hiring only an inexperienced group and pushing out people as soon as they get experience to hire ones that you could justify paying less. That's the fast food example. If you want to take it to the NCAA, I think another way to think about this is, what if the NCAA had a JUCO rule for coaches instead of players? So you can only coach Division I football for 4 years. And if you coached JUCO, we're going to count that against you. That, I think coaches would howl and sue and win in court, that is designed, nakedly designed, to depress the wages of coaches. And there's plenty of people who complain about how much coaches are paid.
Who's the highest paid NIL player in the nation right now?
I do not know the answer to that, Your Honor. It kind of changes every day.
Well, most of them are young quarterbacks, right?
I would say most of them are not young quarterbacks.
Well, I mean, Archer Hanning's a sophomore, right?
He's 21 years old, but
He's a sophomore.
I think he is, by NCAA standards, a sophomore. Yeah.
He's up there, isn't he?
He's really high.
Might be the highest.
I think Sam Levitt with LSU signed a really big deal. I believe Miami, when they got Duke's quarterback, he signed a really big deal. I haven't looked at those numbers recently, but I think they're up to $6 million, $4, $5, $6 million. Yeah. My friend's client has the system that reviews all of these deals as they come in, so he may have better information than I do on that. But I think the coaches, the fast food chain, those are all obvious antitrust violations. The NCAA is doing the same thing with former JUCO players. By limiting their eligibility and counting their JUCO years against them, they drive more experienced players out of that market, which justifies paying players overall less money.
Where's the numbers behind all this stuff? Where has there been a study behind all this where it says, we took a base of 200, or however many guys got D1 scholarships in such a year, and we've gone forward, a lot of them would quit, a lot of them would be hurt, a lot of them would, go back home to their parents. Some of them make the team, some of them get to play, some of them become stars, some of them become superstars. But we don't have a situation like that yet, because how long have we had NIL?
And like this, not very long.
Okay, so would you agree with me that it would be hard to process or make an informed decision from any perspective as to what is going to happen in the immediate future and even in the far future without having a base or some sort of, I guess you would say, a test group that runs through it? How can you tell me what's going to happen in the future when the future is just tomorrow? Today, and you don't have anything in the past to tell me about what will happen, because the past was just 6, 7, 8 months ago. How can you tell me what that market's going to do? Who's going to tell me that?
Yeah, it is a challenge because it's ever
It's not a
evolving.
challenge. I want to know who's going to do it. I have to make a decision.
Right.
I can't base my decision on conjecture and speculation. This is, if you've read, obviously you've read Mr. Gibson's treatise, Gibson Suits and Chancery. It's my Bible. And in there it says, this is, an injunction is one of the most sacrosanct things there is. You just can't hand them out like popcorn. So tell me what proof you have to show me that the harm that you say is going to befall this gentleman, who I respect a great deal, just from his history that I've learned through television and watching him on the field. Very proud to have him wear orange. But how is it going to affect him? And more importantly, how it's going to have an effect upon the actual statute? How does it affect the interpretation of the statute that I have to interpret, because that statute was passed less than 18 months ago, correct?
Yes.
Okay, so where's the numbers?
Right, so I'll be the first to admit that we've had the NIL Go system where these deals are allowed and they're being processed through an NCAA entity. That is basically new. So the data, they have the data, we don't have the data. The data will become available in this case as it goes to discovery.
Okay, so you don't, since, you know, I understand that he is between a rock and a hard place. That's how
Correct.
you put it. Mr. Askew doesn't think so. Maybe not, I don't know. But he has to make a decision, and it's a hard decision. It's a decision that I would not want to have to make, but I don't have a thunderbolt in my shoulder. But how am I to decide based on, you say, well, they've got all this information. How do you know they have that information? How do you know that it's been put into a form where I can analyze it under the law to make a decision? And before we do that, what do we decide, what is the market that we're talking about? What is the market we're talking about, by the way? What is the market that is affected? Because it can't just be every football player in the land. I mean, you can do NIL in high school now in Tennessee. It has to be more attuned to what this gentleman is experiencing. I mean, no, would you agree with me?
Yes, Your Honor, we have an expert economist here who's putting in a report.
I read your expert economist, but he doesn't ever seem to want to put pen to paper on numbers.
Again, the numbers would be the actual NIL deals, and you would have the numbers and the values, and you would see how old the players were and whether they had JUCO experience and all that. You'd compare all that data.
So it puts him at a disadvantage because we don't have history, correct?
It's an impossible
It
situation.
would be like saying, hey, this is the last day of prohibition, and I put everything in terms of whiskey sales because it used to be a whiskey sale. Last day of prohibition, how much vodka are we going to sell in the next 6 months? I don't know, because we haven't been selling vodka for 8 years.
Yes.
Is that what you're telling me?
And
Or is it something different?
No, that is what we're saying. I think that's the second paragraph of that chapter of Gibson's, which says, look, there can be uncertainty. The question for a temporary injunction is who has to bear the burden of that uncertainty. And it's the party who, with all the information you have, you make the best prediction you can about who is likely to win in the end, balancing the equities along the way. So my client has all of the harm. The NCAA has very little harm from him letting him play. He does not have the data. They have the data. They've not provided it. We're going to get it. And then we have,
Let me stop you. You've read Freeman Industries versus Mechanical Company.
yes.
Okay. Do you think that is a particular standard that I have to follow?
The standard in that case, I believe, is that a rule of reason case, Your Honor? I'm not remembering the. Okay, Freeman is interpreting the old version of the statute.
I
And
know, but what's the difference? It goes from services, from things, just all it does is talk about you can't sell things to,
Right.
you can't sell your service. He
Right.
provides the service. So
Correct.
that's good, by the way.
correct.
But that's the only change in the statute, isn't it?
I think that some of the verbiage has changed and made it broader as well, but that is the main change, absolutely. I think the statute was changed mainly to overrule that case.
I need to know before I either, I mean, because this is an immensely hard decision I'm having to make here. But I have to know what standard that I'm going to follow. You know, you've got rule of reason, and you've got this standard that's set forth here under our statute. And that's the one you should know.
Right. My memory of Freeman is that there's not, it's a question, it's a kind of a narrow question. There's not a different antitrust standard. But
Well, let me study let me see what the court says before you jump over that. Key number 12, page 523, we conclude the proper standard for determining whether the case falls within the scope of the QTPA. It's a substantial effect standard. Now, is that what I'm flying under?
No, Your Honor, that's actually not contested. That element of an antitrust claim is conceded by my friends. It's not contested in this case.
All right, Mr. Askew, do you agree with that?
Your Honor, I believe that the rule of reason applies in addressing a substantial effect under that statute would require you to do the same analysis under the rule of reason.
So, are you willing to make that agreement? Because that's the agreement that they made in the Ziegler case.
No, my friend's misstating. The substantial effects test is whether.
Okay, that's what I'm getting to here.
Yeah.
You don't agree on what the standard is that I'm supposed to be applying. I want to know that, because if I apply a standard that you don't both agree on, that just immediately there's an appeal, right? We don't want that, do we?
I think
This
that's,
gentleman needs to know what his rights are.
Your Honor, unfortunately, I think that's inevitable that we're going to disagree on the standard. But the substantial effects test governs whether the conduct has a substantial effect on the state of Tennessee. So Tennessee cannot apply its antitrust law to a merger that's going on in Maine.
Or for a football game that's declaring in Tuscaloosa.
Well, it can apply its law to an athletic association that is not letting its premier football program play its former starting quarterback to the tune of millions of dollars.
Does the NCAA live throughout the United States? Does it have aren't there member schools throughout the United States, all below 48?
Yes, I think it actually literally is a citizen of every state because it's an unincorporated association.
So how does that bear on?
Well, when you do business in 50 states, there's 50 state laws you have to comply with. That's fairly routine in our system.
That's not what they said in the Supreme Court. Didn't say that in Kirk Flood suit, Major League Baseball.
Your Honor, that flood decision, I believe there's a Ninth Circuit, I believe, decision, or Second Circuit decision that's.
No, the flood decision is the Supreme Court case.
Right, and that.
With the reserve clause, you know that. But it's the same, it's just a different rule. It's the same effect, is it not?
No, Your Honor, I think.
The effect is that you have, if we pass a statute here that allows him to do things here, which would be wonderful, does it have extraterritorial effect? Can we just say, Tennessee law, sorry, Columbia, South Carolina, we're going to play today, and he's playing because our law says this.
Yeah, that is perfectly fine, Your Honor. I think the pork producers case couldn't be clearer on this.
Okay.
If California sets the emission standard for cars, it affects.
We'll have to do an in-depth on that, or Mr. Askew's probably going to tell me that what you're saying is probably wrong.
Right. I would be surprised if every state's antitrust law as applied to the NCAA is unconstitutional. I don't think any court has ever said that. And I would also be.
I don't think that they have either, but you just told me twice that this is as broad a one as there is.
It is also settled, and I think we cite a case in our reply brief to this effect, that state antitrust laws can be broader than federal laws, and that also doesn't make them unconstitutional.
But the Tennessee state cases say you have to interpret our antitrust law so it doesn't violate the Constitution, do they not? That's what this case says.
I think you always want to interpret statutes that way, sure, yes.
Yeah, so if ours is super broad, with a broad S, and we have to interpret it so it is not so broad as to violate Article 1, Section 8, that's the correct section I'm talking about, right? Paragraph 2 of the Constitution of our great United States?
Yes.
So we have to cut it down. Even the Supreme Court says, I think this is the Court of Appeals. No, this is the Tennessee Supreme Court, 2008. How do you fix that problem?
Your Honor, I think my understanding of the law.
You're going to say pork producers.
I mean,
Aren't you?
it is a U.S. Supreme Court case from 2 years ago that changes a lot of this law, so it is, I don't want to sound like a broken record, but it is an important case. But I think the law is that when something affects the state, it affects Tennessee in a substantial manner, to Freeman's point, the state can regulate that conduct, even if that regulation has effects outside of the state. And whether this conduct affects the state of Tennessee in a substantial manner is not contested by my friends, at least at this point in the case.
Well, let's just say that it's your burden of proof. And how substantial is the effect of what you're asking me to do on the state of Tennessee?
If you look at the JUCO rule, Your Honor, there are JUCO athletes in Tennessee. There's 10 Division I schools in Tennessee that it affects. The obvious effect in this case in particular is that the former starting quarterback, presumably, hopefully the returning starting quarterback of Tennessee, it's valued at $1 billion in terms of revenue to the state and to the community in Knoxville, that their starting quarterback cannot play. For him individually, that's $2 to $4 million immediately, which is a substantial effect on interstate commerce. But the broader effect on the University of Tennessee is big.
As to what? As to the total amount of our interstate commerce, or just to him?
Either is satisfied in this case.
But what is the income or the value of goods and services sold in the state of Tennessee as compared to him? What is that? Do you know what that number is?
I do not, Your Honor. I don't think that's the test.
Is that in the tables of the Tennessee Code annotated? Can I find that?
I don't think to violate the antitrust laws, you have to be weighed against the entire commerce of the state. I think you have to have a substantial effect.
What is the market that we're talking about then? What is it?
I'd love to, the market. The market is defined as Division I college football players.
Okay, so I'll ask you the same question. What is the effect of his $2 to $4 million on all of them?
I think the question, Your Honor, if I understand what the law is asking, is what is the JUCO rule doing on that market? And the JUCO rule on that market is boycotting a class of athletes. And when you do that, the courts say, not only is this a kind of a well-known phenomenon, but you can use basic economic logic to figure this out. My fast food example, my coach's example, that depresses wages. It also just flatly, by design, decreases competition, which is what...
Depresses wages?
Yes. Because if you take the more experienced players out of the market, you can justify paying the less experienced players less. That's the NCAA's rationale for this rule.
How much is this, his successor getting paid, the gentleman from North Carolina? How much is he getting paid in the NIL compared to him?
I don't know the answer to that, Your Honor, but he's on the team and will remain on the team no matter what happens to my
I
client.
understand that, but we're talking about wages, and you're saying it's depressing wages at the back end, but not the front end.
Well, the JUCO rule does not affect the sort of five-star freshman. The JUCO rule,
Then what is the market?
within the market, it affects a different type of Division I player.
Well, then what is the market?
The market is Division I college football players. I think that's the market in Alston, it's the market in Pavia, it's the market in Martinson.
I'm going to have from you before I can make this decision. Is either you're going to tell me what exactly the market is that we're talking about, and you give it to me in such uncertain terms that I can write an opinion about it, or you'll be too nebulous and speculative. Well, if I don't know what the market is, how can I tell which market's being affected?
Your Honor, it's the market that is identified in all of the cases that go our way.
They're identified variously, and almost every case they're identified differently, particularly by your own expert.
I think with respect to the JUCO rule, he has been consistent, and he's since clarified. I think our expert did a good job responding to some of the criticism he got from a few courts and defining it clearly. It's Division I college football. That's where all the NIL is. That's why it's the relevant market. It's where all the compensation is. That's where the highest talented players are. That's the type of athletes that these schools are competing with each other for, except they're getting together and agreeing not to bargain with a class of them, which depresses wages, but by design, it also decreases competition.
They're getting together and agreeing not to bargain with those that are aging out. Is that what you're saying? They already had 2 years of JUCO.
No, there is no aging out bargain. They don't care how old you are.
Well, no, they've had 2 years of JUCO.
Right.
Of the 4 years that they can play. You're saying that portion is their wages are being artificially depressed.
Everyone's are.
Or is it everybody?
Everyone's are. So,
Do you have any proof of that?
yeah, we have. It's the basic economic concept. We've got an expert. We know that my client stands.
Do you have any analysis of numbers that show of these 10 quarterbacks that are JUCO? And some of them are getting ready to come through with their eligibility under the rules as they exist now. And 6 of them are their income's being depressed. You have an analysis.
This is the problem we discussed a few minutes ago. Of the data is new.
What I'm trying to do, under the rules of procedure and under the rules of evidence, I have to be able to substantiate what I say. With evidence, not conjecture, not I have to be able to put my finger on a graph grid, the bottom line, unless, and I go back to this Freeman case, it says determination of whether effect is substantial does not involve mathematical nicety. Rather, the test is pragmatic, turning on the particular facts of the case.
That's right.
Then, the anti-competitive conduct, however, need not threaten the demise of the Tennessee business or affect market practices so substantially, affect intra-state commerce.
Right. Yeah.
Is that what you're wanting me to do? Is that what you're wanting me to do?
Our test is no different from that test in terms of the effect on intrastate commerce.
And you're saying Mr. Maxey tells me that?
Yes, Your Honor. I think, and you look at all the cases that have gone our way under the federal law. You look at the professional cases that we cite in our brief, where there was collective bargaining that came in later for a lot of the professional leagues. Before that,
This has nothing to do with collective bargaining, I don't think.
right, exactly. And before collective bargaining, the antitrust laws applied to the professional leagues. All of their rules restricting the age and the amount of time you had to have played to get into the professional league were considered illegal under the antitrust laws under a quick look analysis.
I don't think there was ever a rule that said you had to be of a certain age to play professional baseball unless it was 14. Joe Nuxall played for the St. Louis Browns when he was 14 years old.
Yeah, baseball is a particularly bad example because they have a sort of a
Exemption.
they have a weird exemption, yeah. But the NFL does not have an exemption. There used to be a rule that you cannot get into the draft until you were a certain age. The NBA had the same rule. The NHL had the same rule. Courts struck those down until there was collective bargaining introduced, which is a new exception. And so, and this is where quick look review comes in. We can win without the data because it makes basic economic sense that when you remove a class of competitors, you decrease competition. And that's actually, you also don't need data because that's my friend's rationale for the JUCO rule. They say,
What you're saying is if I've got 100 participants and I take 25 out of them with this rule, that the 25 on the back end are going to get paid less because these people were taken out.
if you have one more piece of information, which is that the 25 have more experience than the remaining 75. That's the JUCO rule.
Well, no offense to your client. Never would want to offend you. What if there's some kid from Pig's Knuckle, Arkansas, that can throw a football through a battleship and is unbelievably accurate and can scramble, he's Michael Vick, and has a cannon for an arm? He's going to get paid more than your client, isn't he, coming out of high school?
Right, and he's going to, in a fair competition, he's going to win. That's the point of the antitrust laws, is to make us compete against the best and figure out who gets up on top, not take out a class of competitors. So the question, this is a great example. So the 25 you take out. The NCAA would put in 25, by definition, less experienced people in those spots. That's why wages go down.
Less experience, but experience in this day and age of college football. Take a kid from Alabama, Downs. He's one of the best defensive backs I've ever seen. But he takes his abilities to Ohio State his sophomore year. He's only 19 years old.
Yeah.
I mean, aren't there just as many people waiting in the wings that are going to be him?
They're not the people who get beat out by JUCO players. Those people are going to get in anyway. They're in the 75, not the 25. The 25 are this is the reason for the rule. They say that if you let JUCO players stay in, then it'll push out certain people who are less experienced and have never gotten to play. And that actually sounds like a pretty good fairness argument, but fairness arguments are not relevant to the antitrust law. Section 105.
You're looking at the law.
Yeah, Section 105 of our statute says you can only look at the effect on competition. And it is, by definition, anti-competitive to remove 20% of the competitors from the field. And so I do think the quick look cases are.
Do you think that anything that, with regard to any of the other of the bylaws, Mr. Ashton's client, have anything that weighs against your client with regard to he's been in school for X amount of years? And we're wanting to move the progression of students through school. It's not just, although I don't agree, I don't know what they actually believe because I can't read their mind. But they say we want to foster education and athleticism. I don't believe that matters.
I don't think anyone believes that, Your Honor.
Does that have any effect on the argument that you're making here?
No, I mean, I don't blame them for trying to defend their rule with a rationale. I think under Section 105 of our antitrust statute, those rationales are irrelevant because they're not about competition. That is a valid, worthy purpose to have people graduate. It is a valid, worthy purpose to worry about the freshman who might miss an opportunity. That is not competition. The competition is all our laws care about. 105 says that's all a court can consider. And what the other courts have said, even the courts that have gone their way, don't like these arguments very much from the NCAA and have said, the only way this is possibly relevant is if pushing out the JUCO players increases the appeal of college football because it promotes amateurism and it makes it a better product for the consumers. There is no evidence whatsoever that consumers care about the level of amateurishness in college football, that they perceive it to be amateurs now when the players are getting paid. There's the transfer portal, which a lot of people complain about. It doesn't look very much like amateurs who are just trying to graduate. In fact, when you transfer, it really sets you back, typically, in your academic progression. They have all these exemptions for, there's a COVID waiver, there's medical waivers, there's red shirts. They just expanded the red shirts so you can play 9 games and still not have that count against you. You can go to the Olympics, you can go to the military, you can go to a prep school, you can go to play professional baseball and then start your college football career at 30. That's totally fine. Like all of these, and there's professional basketball players from Europe who are coming and playing in NCAA. There's all these, they're just riddled with exemptions that they can't really prove that the JUCO rule is sort of the key to amateurism. And that's why even the courts that go for them when they get to this stage say the NCAA is going to lose. And of course, just our baseline position where I started, Your Honor, is we're not here to blow this all up. We're here for one client in 1 year. I understand these things have broader implications, but our rule is basically their rule, that to keep college sports college, you get 4 full seasons. You get 4 full seasons at an NCAA school. My client has had 3. He's asking for 1 more to make money with his God-given talents 1 more time and to improve his ability to get drafted by the NFL. That's it for me, Your Honor.
All right, I'm going to give you a chance after this. I'm going to let you have your first shot at it. He's going to talk. I'm going to let you reply. And then if necessary, I'll let you have a minute or so on each side to basically take pot shots at each other.
We do that a lot. So. Thank you.
Good afternoon, Your Honor. Taylor Askew on behalf of the NCAA. Before I jump into anything, there's back and forth discussion with Mr. Norris, and if Your Honor's got questions on the front of your mind, I'd like the opportunity to answer those, but I'm sure we'll get to that. Despite the notoriety and attention that this case gets and the very impressive, important young man sitting to the right of me here, we're here on an injunction. It's got a standard. It applies to all injunctions. What do we know about them? They're extraordinary remedies. That's what they are. When they change the status quo, and the status quo here is that Mr. Aguilar is not eligible under NCAA bylaws, it's a higher burden. It's got to be very clear. 4 elements that go into that: likelihood of success on the merits, or the threat of irreparable harm, burden weighing on one part or the other, and public interest. If we're starting with the substantial or the likelihood of success on the merits, substantial likelihood of success on the merits, we have to tie it to a claim. We can't just grant an injunction because it seems equitable. We have to tie that into a claim here. They're moving under the state antitrust statute. Your Honor's locked in on the Dormant Commerce Clause analysis there. Flood v. Kuhn, the United States Supreme Court has looked at a national sports conglomerate league and said, we don't just take one state's antitrust law and apply it and make everybody abide by it. That is patent undue burden on interstate commerce. We don't do it. The state law antitrust claims in that case were dismissed. The Supreme Court upheld that dismissal. That's what we have here. And regardless of whether this is the broadest state antitrust claim or state antitrust statute that we've seen, it doesn't matter. It's the fact that one state can't regulate all the other states. Tennessee would never accept Florida saying this is what you have to do. It's not how it works. And we know it regulates interstate commerce. The N in NCAA stands for national. It's across the country. So from out the gate, the claim is barred by the Dormant Commerce Clause. But if we get into the substance of that claim, the substantial effects piece that Your Honor was touching on a moment ago, that's the threshold issue here, is do we even apply this statute to begin with? And that's where you look at the substantial effects. Does it have a substantial effect on the interstate commerce? And that basically just means if this just has a tangential relationship to Tennessee commerce, we can't just apply the statute to that. It has to have a substantial effect. But once you get past that threshold, we're back in rule of reason land. It's just the Sherman Act. It's the same analysis that federal law applies.
Okay, stop right there.
Sir,
Is there a case, and I don't think there is, that says the same analysis applies under our state statute that applies under the Sherman?
not in those words, but they use the rule of reason. And
They say it mirrors that, but it doesn't say we're accepting that. It doesn't say we accept this as the law. We say, and for part of that reason, why I think it was the Aguilar case, is that the parties agreed that the rule of reason applied. Before I go jumping through that hoop's on fire, okay? I want to know that I'm right. So that may be something I'm going to ask both of you.
absolutely. That's perfectly, the answer to that question is no, there is no case that specifically says this is the exact same analysis. But where does that leave us? There's no other case that says it's a different analysis. And if you look at how the cases analyze those claims, they do it in a way that at least leaves us with just the framework of how they do it federally. There's no other way that's been proffered by any court for us to look at this. And so if we're going to go by guidance, that just the guidance alone in those cases, we're stuck with something at least analogous to the rule of reason, even if we don't call it that. So to start with, even if we call it a rule of reason light, Tennessee rule of reason, we still have to define a marketplace. We have to. What is the relevant market? We have no idea here. We have something that's been asserted to be the relevant market, the market for Division I football, but we don't know who's in that market. We don't know if there are substitutes to that market. Your Honor identified that NIL deals are being given to high school kids. Should they be brought into the market? If bringing JUCO players back in, would that depress wages, if their theory is correct, to high schoolers? If so, high school's got to be in the market. If bringing back JUCO players increases or decreases wages in the NFL to late round draft picks, to preferred signees, that's got to be in the market. We don't know if it is or not.
Well, let me stop there. You know, I'm not trying to put you off.
No,
Mess up your.
I'll mess it up
You've done
myself.
this so many times, I assume you'll be able to go right back to where you were. But if I have a case like this, just hypothetically, there's no market that can show me what the rise or loss is in the competitive nature of what's going on within that market. Because one, there's not been enough time, or two, there's not enough data. Does that leave him without a remedy?
It leaves them without an ability to get an injunction.
Well, no, this is a court of equity, correct?
Yes,
Now, and you heard me say 20 minutes ago, this is one of the hardest things there is.
absolutely.
But if the law is in a state where a person who has a loss which may be defined, could be defined, but for the lack of the passage of time to make a statement of what that actual loss is, other than his ability not to play football. Which you have to admit, there are cases that say him not being able to play football is irreparable harm, correct? There are cases that say that.
There are cases that say that.
Okay, but to get back to the trust, the antitrust, Tennessee antitrust, there has to be a remedy, because the law, a maximum of equity.
Absolutely.
The law abhors damage without a remedy, correct?
Correct.
So what is his remedy?
Well, we know for one, we're talking about at least some money. So we've got a monetary remedy at the end of this. What we also have is the ability to take the case, develop the record, get the data, put it into a
Stop, please. You played sports, did you not?
I did.
What's the biggest crowd you played in front of?
I gave up 3 sacks to Geno Atkins at Georgia.
Between the hedges.
Pretty bad, yeah.
86,000.
I think so. 90-something, yes, sir.
Okay. What would you give to put your helmet back on and go back between the hedges?
Oh, not much for that game. But
Period.
no, it was a life-changing, and I'm not here to tell you that I think any college sports is anything other than one of the most important things that ever happened to
Well,
me.
I'm telling you, that's what he wants to do.
Absolutely it is.
And I'm not, you haven't seen me without my robe on, but if you did, you say, well, that guy's never, ever had a chance to play NCAA football. That's part of the problem, is that I have, is that when it comes down to it, I have to give him something if he's been harmed, do I not?
You do. If he's proven a claim, you do. Absolutely.
But if it's incalculable of being ascertained, except through something that's already been found to be irreparable harm, his lack of ability to play sports. How else do I measure it? And in what market does that fall in? Because he plays NCAA football, correct?
Yes,
And he plays it at the highest level.
he does.
Okay, so there's no value, there's immense value to it. There's no monetary value to it, is there?
Well, I think if we're discussing this, are we discussing it within the context of an antitrust claim or just generally to
I'm
Mr.?
discussing within the terms of, I'm not saying that I agree with you or not, but I've read the 1,200 pages that you sent me yesterday. Okay? I didn't read them, I didn't commit them to memory. But I've read their experts, various trial testimony, deposition testimony. Just because he can't put a number to something, as far as a decline in the market or a rise in the market, how, does that mean he gets nothing, takes nothing from his score?
I think it means that he doesn't have a substantial likelihood of success on the merits of a claim. And when we're discussing,
And I don't mean to interrupt you.
no, I appreciate it.
What I'm trying to figure out is, I've known Judge Ashley since we were kids, 18. And the other judges that look at this quick look, and I'm not saying that they just pushed this off because they didn't want to make a decision, because I know Judge Ashley, if he's not one to mince words, he will tell you what he thinks every time. But this is a problem that demands an answer. And just because I can't put it down to 78, close enough to be 78 cents far backwards or forwards on what his actual damages are. I've got at least one case here that says basically you don't have to define it to a mathematical certainty under the TTA, under the trust statute. This freedom, but am I talking apples and oranges, or what I'm trying to ascertain is I think he has some kind of damage. And I think that the statute, under whatever analysis we apply, that there's a question as to how well you can define the market and what the effect on the market, because the lack of ability to crunch the numbers given the fact that it hasn't existed for very long. So, does that affect his ability to succeed upon the merits right now? Well, you know and I know that some of these cases within this board and cases across the street in federal court, some of them last for years.
They do.
But how, am I to just say, he's got irreparable harm that can be ascertained, but I'm not gonna give him any relief for it because I don't have the numbers right now. Am I supposed to do that?
If we're following the law, yes. I don't think he can get an injunction without the proof on the claim. And that doesn't mean that this isn't an impossible decision and a very hard decision and a decision that we don't necessarily. But, I mean, I'm not standing here saying that this isn't a sympathetic claim or that Mr. Aguilar is not in a position that I wish that he were not. But the rules are the rules. And the rules as they exist now are the rules that everybody agreed to play by. Everybody, the notion that the NCAA has created these rules and then sent them out as a memo to the schools and say this is what you got to do is wrong. All of the schools got together and they agreed upon those rules and then sent them to the NCAA and said enforce these on our behalf.
Let me ask you, when was the JUCO rule passed?
I don't know when it was passed. I know that it's been in existence much longer than NIL, so it could not have been enacted
I'll
for.
tell you this, that when I was a kid, which was way before you were born, that one of the greatest quarterbacks in the history of the University of Tennessee, Connor Charlway, did not play his freshman year because he couldn't, and the NCAA wouldn't allow him to. That's why they had JV games.
Mhm.
So what are we talking about here? They cut him off on the back end, and on the end of the career, they're cutting him off now. I mean, it didn't happen to him because it was 1974. He was probably born yet. But you gotta have, what's the change in the rule there? Why was a freshman not able to compete then, but you're trying to preserve what a freshman can do now, and what's?
Yeah, well, the membership got together and changed that rule. That's what they did.
That easy.
I don't think it's easy, but everybody agreed to it. That's what happened.
Don't know.
I don't know why they changed that rule. I don't know what the rationale was at the time. But I do know that the suggestion that junior college is a punishment is wrong. It is not a barrier to entry into the NCAA. When you enroll in a junior college, you're just as able to go to a Division I school if there's a spot for you. It's not as if, oh, you've gone to junior college, that means that that the NCAA did not allow you into the Division I ranks. There just wasn't a spot at the time. And the reason that counts against your NCAA clock is because the NCAA counts intercollegiate competition, which means representing a degree-conferring institution at any level after high school. That's just what the membership has agreed to. And that's how they count it for everybody. It's not being applied detrimentally to Mr. Aguilar or anyone else. It's just when the clock starts. And the clock runs. And there are exceptions to that, absolutely. And every single one of these cases, it says, well, oh, this person got an extra year. You can look at those cases down to the letter and say this rule was applied there. It's not arbitrary. They are applied to the letter. And so what we're left with
You're
here.
saying that the NCAA doesn't apply cases, apply the rules arbitrarily?
That's what I'm saying.
That's not what the judge found yesterday.
I was there.
Yeah, I know.
Yeah. I remember. But if you look at that record itself, it was not an arbitrary application of the rule.
Somebody with the same dress on that I had.
I don't win them all. But when we're talking about a remedy here, we can't just make one up without a legal right to it. And the legal right to it comes from the stated claim and proving the claim. And if we don't have a claim that we can prove, we don't have the right to the remedy that we want from the unproven claim.
Would it be akin to his cause of action hasn't approved yet, maybe?
To the extent he has pled a cause of action, that is different to whether or not at the preliminary injunction stage he has enough evidence before the court that this court can make a decision that he has a substantial likelihood to succeed at this early stage, and it should go ahead and award him the ultimate remedy in the case.
There's a back-end comment on Rule 65 as to when, like, there's a substantial chance that he can succeed on the merits. How far out in the future do I get to cast my bait and reel it back in? Is it 2 years, 3 years, when there's enough time for these studies to be done?
Well, enough time for the study to be done for certain, and
But then, but when I say that, he's losing out. There's a hole in the wall.
there
Isn't
is,
there?
there is also a duty on a party to a civil lawsuit to assert their cause of action in a timely manner. This case was filed a couple weeks ago. He was a part of the Diego Pavia case and then non-suited that. That case was heard on Tuesday. Still waiting on a ruling there. This same expert that they've offered to you, I cross-examined him on Tuesday in federal court. He once again admitted, I have no data. I haven't done any of these studies. It's just my theory. I think it's right. I don't know. I haven't tested it. Again, that's where we are. But to say that the NCAA should have to come up with the remedy for Mr. Aguilar because this case was not filed until a couple weeks ago, I can't.
I don't think that that's what they're saying, but maybe it is. But I will tell you, there's a Tennessee case. There's lots of cases in the cases where if you can prove damages, you have damages, but you don't have to prove damages. Okay?
Correct.
What you're saying is he can't prove any damages.
What I'm saying is, if he can prove this claim, and he has lost this opportunity because the NCAA's rules that were agreed to by its collective membership violate an antitrust law, he has proven he lost those NIL opportunities, and he's got that money damage. If he wins that, he can have his eligibility back because kicking him out would have kept him out, and it would have been unlawful. He'll have the ability to come back and play football if he wants to. Ask for an extraordinary remedy. So looking at that piece of it in and of itself, we don't know what the market is because it hasn't been defined. It hasn't been tested. We don't know the boundaries of it. And under all antitrust cases that apply this kind of analysis, if you don't know what the market is, you cannot go any further. You don't know if there's anti-competitive effects in the market because you don't know what the market is. But assuming that the market for Division I football is a proper market, just assume that. There's still no evidence of an anti-competitive effect. And that is a bunch of legalese for saying there's no proof that but for this JUCO rule, everybody in that market would make more money, that the JUCO rule is pushing down the amount of money that is here.
And I'm not asking you to do this because I can't make you do it. I can't make you ascertain this. But what is the best source of information for that, for the particular information that we're seeking here? It would be the NCAA.
I'm sorry, I missed because of the cough. I just didn't hear the first part of your question. I apologize.
What would be the best place to get the information in order for him to set the amount or the effect of the statute on this? Would be the NCAA.
We do not gather all of the NIL deals. We do not have those. It would be at the institution level through third-party subpoena.
So someone making a study.
Yes.
Ish.
So, or perhaps Mr. Pavia, who's had his case pending for a year and a half now or so, could have taken any discovery whatsoever. But he has yet to serve an interrogatory, a request for production, or a subpoena.
33 or 34.
Nothing. No,
Nothing?
none. Nobody has taken discovery in any of these cases.
Have you taken his deposition?
Mr. Pavia's? No.
Have you taken any depositions of the plaintiffs?
We have deposed some of the plaintiffs in the most recent Patterson lawsuit. We deposed some of the players in that one. We have taken the deposition, or we've taken live court testimony of Dr. Maxey, I believe, 4 times. But other than that, no, the discovery just doesn't move forward. This is the end-all be-all hearing for the majority of these. And nobody proves it up after the fact.
Well, I've tried many DRO cases in these 3 rooms here, and most of the time it ends up being a miniature trial. Good. What you're saying is, so what?
And out of all due respect to Mr. Aguilar, it's just not my burden.
I didn't say it was.
Oh, no, but that's 100% correct. We're not putting on any proof because we don't have any we don't have any burden to prove anything.
It's your position, your client's, that until they can come forward with proof that shows the claim falls within the act, and that there is an effect, that you have no duty to do anything other than say, sorry, tough.
Until that is completed, there is no burden shifting. I'll give you a straight answer on that, absolutely. There's just no burden shifting.
Anything else you want to cover?
If we're talking about the likelihood of success in the marriage, we've discussed that we don't have any effect of competition being depressed, and it cannot be tied to just one individual or a group of high-performing individuals. It has to be a market-wide harm. It has to be an impact that is felt by all participants in the market. This JUCO rule, in order to find an antitrust violation, the exclusion of JUCO players must depress wages for even those who did not play JUCO, for it to be a market harm in the market that they assert as the definition.
I'm going to stop. Would you allow that to be stated as the market, all of the participants? Would you allow that to this statement to be stated as the market that we're traveling under?
Can you restate the market?
Madam Court, could you read that back?
Which part do you want?
The last statement that Mr. Astor just made.
For those who did not play JUCO, for that to be the market harm? Is that what you're,
Yes.
okay.
I don't think I agree with that, but I also pretty sure I don't understand what that market is.
To the extent I was unclear, what I mean by that is if the market as defined, if the market as asserted by Mr. Aguilar is the market for Division I football players, the harm that is felt as a result, the alleged harm felt as a result of the application of this JUCO rule must be felt by all players in that market, not just those who played JUCO. Because there are other players in that market for Division I football players who did not play JUCO, which means that the anti-competitive effect of this rule has to go beyond JUCO players in order for it to be an antitrust injury.
Because those people are within
The market.
section.
Right.
If you're doing this is in terms of subsections and sections, everybody who, including JUCO, is the section.
Right.
The subsection is irrelevant.
Right.
Because it doesn't matter. It could be somebody who went on a mission for the Church of Latter-day Saints for 2 years, or it could be they were in the Army or whatever. It affects everybody.
Has to affect everybody.
Would you agree with that?
No, Your Honor, that's Alston, all the payments weren't going to all the players. Not all players wanted to get in the transfer portal. That was an antitrust violation. They had to change. Every case that they've lost, that's not been true, including at the U.S. Supreme Court.
I'm not asking about every case that they've lost. I'm asking about this case.
Right, and this one
Then
is,
tell me what the market is.
it's Division I college football players. It does include non-JUCO players in the market, yes. And our evidence is that it depresses their compensation.
And your evidence is theoretical, correct?
Yes, as is theirs.
Yep. And on top of that, it doesn't make there was a statement about roster limitations earlier on. There is a roster limit. It's 105 per Division I team. That's what it is. There are other players above that limitation right now for a short amount of time. They are called designated student athletes. And the reason they are designated student athletes is because when the Ninth Circuit approved the House settlement, the court was concerned about the effects of current walk-on players. And the settlement allowed those schools at that time to designate players who were on the team above that roster limit to continue playing out the rest of their career. It is not a permanent thing. It is an equitable thing for the players that were already on teams at the time. There is a roster limitation.
And when the last of those persons graduates?
It's done.
We're going to school time.
Yep, it's grandfather. And so if we're talking about economic theory here, right? Let's apply just a basic economic theory to this claim. Supply and demand. Supply and demand. What do we know about that? Supply goes up, demand goes down. What they are proposing to you is, let's add people back into the supply pool. We know what the eligibility criteria are. JUCO players are out of eligibility. Add them back in. Let's add more supply in, because adding more supply will increase the demand. That makes no sense. It makes no sense. And we know that the demand can't go up because there's a roster limit. It's stagnant. There are only 105 spots. Adding more people in to fill those spots does not drive up the cost to fill the spots. It can't. And on top of that, there's this other issue, which is the house settlement cap, which is not an issue here. It's not a collateral challenge to that settlement agreement. This is not what that is. But the schools are capped at the revenue sharing of 20.5. You can't, that's already what it is. You can't drive above that. That's a judicially approved cap here. So those two things alone.
But we're not talking about that.
Correct, but I am saying for purposes of demonstrating an antitrust injury that these wages have been depressed by this specific rule, supply and demand says that makes no sense, and we already have a cap at how much can be spent anyways. So,
That doesn't include independent people who get the money.
correct, but as the Ziegler court found, it is not an antitrust injury for a rule to cause secondary effects outside of the market. Because what third parties do with respect to NIL rights falls outside of the NCAA and the proposed market with the Division I football players. It cannot substantiate that claim. And finally, and I'll sit down, but the suggestion that there is no harm to the NCAA is respectfully incorrect. The NCAA is not this building in Indianapolis. The NCAA is all of the Division I member institution schools. Every time one of these judges somewhere rules one of their players eligible, beyond where there's no proof in the record, there is a collective groan across the country. You can see it on Twitter. Say, oh man, this is ridiculous. And why is that? Because the rules are being bent in favor of one participant. And the other players, all those schools who agreed to play by the rules, have to play against those schools. The Lewis Moore case that was referenced, I litigated that one. That was over in Texas. He didn't get the Pavia waiver. That case is on two different appeals. One for personal jurisdiction because it had no business being in Texas, and two, there was no stated claim. He should not have been playing. The player at Texas A&M that was brought up at the Alabama hearing last week, he should not be playing. Nobody has proven these claims, but every team that has to compete against them is playing against somebody who has more experience or otherwise is not abiding by the framework that everybody agreed to abide by. And I love Tennessee football. I'm from Knoxville, grew up watching it. My kids watch him every game. But at some point, when judges are looking at records like this, and in Tennessee, we have to say, Tennessee is better than this. We're better than this. We don't have to go to court to get our guy back. We don't have to play somebody who is ineligible under the rules to win games. We don't do that in Tennessee. And we can make that decision without taking anything away from Mr. Aguilar in terms of how fantastic he was. You're a hero to kids around this city. Fantastic. And we can't take that away from him. He will always have a home in Knoxville. We didn't know who he was until Nico left, and then he came, and it was wonderful. But that doesn't mean we break the rules. It doesn't mean the Vols get something everybody else doesn't, unless and until the claim is proven. And until we do that, we play by the rules. And that's all we're asking. It's the status quo. And until there's proof before you that we can feel comfortable is persuasive enough to give an extraordinary remedy, we stick with them. And for that reason, Your Honor, I ask that it be denied, and I thank you again. You were fantastic.
All right, the court's going to take about 10 minutes, then I'll let you each have one more bite at the apple. All right? I'm going to ask you some questions.
You can remain seated. 305.
If he didn't, I'll check with him. And if he didn't, then I will.
I will tell her my name.
Okay. Yeah, I can do this.
What's your firm?
Holland and Gunn.
Is it ASC? Oh, okay. Thank you very much. Okay. Okay, thank you.
Take me here about an hour. Say three, I'll buy you one. Yeah. Y'all want a pretzel?
I do, Ken. You still eat those?
Huh?
You still eat those every day? No, no.
I'm thinking I'm good. Okay. Yeah. You can do that.
Thank you, Your Honor. I think we ended with a very impassioned defense of my client, which I mostly agreed with from my friend Mr. Askew, that he is an inspiration, that kids do look up to him, that he is the model of hard work, believing in yourself, coming off the bench, starting from the bottom, working your way to the top. He is what makes college sports awesome. He's one of the best stories in college sports. He's an inspiration. He is an economic driver of the city of Knoxville. That is why we're here talking about restrictions on trade or commerce. That is all related in exactly the nature of the legal violation. And all of the things my friend said about my client are true. My friend omitted the fact that his client is the one here choosing to not let my client be eligible for one final season of college football, even though the rules that we all agreed to were 4 seasons. He's had 3 NCAA seasons. He wants number 4. All these things are avoidable. They could have given him a waiver. They give waivers out all the time. There's players who are in their 7th, 8th, 9th year of eligibility because the NCAA chooses to let them. It does not apply the rules consistently, and so it's hard for them to stand on something like the rules are the rules, given the way in which they behave. They say
You're arguing this now. Is there proof of that in the record?
that there is proof in our brief about the 7th, 8th, 9th year of eligibility.
Brief, but it's not proof in the record. Do you have proof in the record of what you just said?
We're stipulated that those sources are part of the record, but they've given out 7th, 8th, 9th years of eligibility just in the last 2 weeks, and that's in our
Where is
brief.
that cited in the brief?
It's in a couple of, maybe footnotes 2 and 3 of the reply.
Okay.
Yeah, the Alabama player is a defensive lineman that Tennessee's going to go up against, who's the 7th year of eligibility. There was a Montana player, I believe, who got his 9th year of eligibility granted by the NCAA. My friend said, these are the rules, and everyone agreed to the rules. The NCAA is a monopoly. That is conceded in this case. It's not contested. It's established by the U.S. Supreme Court. It's obvious. Standard Oil can't say, here's the price of gas, and those are the rules. Monopolies have unusual market power to coerce and constrain and to have adverse effects on commerce in the state. It really is all just a question, it's all question begging of whether this particular rule violates our state antitrust law or not. And we think it does. We think the question today is how likely is it that it does when you get all the evidence in? And I think this is the major issue.
How likely is it?
Yes, Your Honor.
That's not the standard of proof in a civil case, is it?
It's the standard of proof on a temporary injunction, Your Honor.
Well, how likely, that's one of the factors to be considered. It's
Right.
not standard proof. The standard of proof is you have to prove things by preponderance of the evidence, correct?
To
Or
prove-
very convincing evidence. And have you done either of those?
Your Honor, it's a question of law whether they violate the antitrust laws, and the question is whether that's
But what's
likely.
not a question of law is, under this statute, which says, which we've been talking about it all day, or at least half a day, all arrangements, contracts, agreements, which this would be an agreement,
Correct.
between persons or corporations made with a view to lessen or which tend to lessen full and free competition in trade or commerce affecting this state are declared to be against public policy unlawful and void. Would you say that that's why we're here?
Yes.
Okay, I want to ask you, and I'm going to ask you, I've asked you several times. How does their enforcement of these 2 rules that we've been talking about substantially affect this state?
Because we have 10 Division I schools that are part of the creation of these rules
What about the other Division I
in the state,
Okay.
in Tennessee.
How does it affect that? How does it affect this state?
It restrains their ability to have former JUCO players play the full 4 seasons of college football. It affects those players. It affects players who want to come to Tennessee. It makes those teams less competitive because we were all admitting that we're replacing more experienced players with less experienced players. It affects the University of Tennessee, which is has itself is a major part of commerce in the state. It deprives them in this particular case of their starting quarterback. We put in uncontested evidence about the economic impact of the University of Tennessee football program.
Well, no. Let's talk about that uncontested evidence. As you said, you put in proof in your brief that our football team made X amount of dollars, correct?
Yes.
How did whatever they're doing cause that to go up or down? And how much did it?
We don't have causal evidence about the JUCO rule, Your Honor. I don't think that's the standard. The point is that
No. You're saying you don't believe that. I have to write a brief. I have to write a memorandum of opinion on what the law is compared. Now, there has to be number that you have or the number that happened before in order for this to have an effect, does it not?
I think so, Your Honor. I'm not sure what the denominators we're talking about.
What?
The denominator, like, what, are we talking about effect on the?
What we're talking about is you say that this is how much the UT football is worth to the state of Tennessee, right?
Right.
Okay, well, how much would it be worth without him?
Right.
How much?
I don't have the number. I think,
And
I
who
think,
does? Nobody does, right?
no, that's a pretty tricky economic calculation to have the
Well,
precise amount.
Nobody does, right? Does
Not that I know
anybody
of.
you know of have that number?
No.
Okay, does anybody that you know of have the number before he played quarterback here? When Nico was playing quarterback, or when Randy Wallace was playing quarterback, or anybody of the 70, 80 quarterbacks that have played here in the last 30 years?
No, we know that 2025, where there was no JUCO rule and Mr. Aguilar was playing, was the best year ever. But
Okay,
that's all we have.
Was there any other additive or causative factor with regard to that, that you can either take out or add in, like inflation, or selling beer, or, you know, they just started selling Miller beer over there about 6, 7 years ago, and guys, I told you, I like everything to sell alcohol there. Did that have any effect on it?
I'm sure there's
You don't-
multiple
you don't-
effects, Your Honor.
You don't know, so you can't tell me what the causative effect is, then, can you?
Right, and I don't want to say that I have to prove that the value of Tennessee football is tied to the JUCO rule. I don't think I do.
But you have to have some sort of effect.
Right, you have to have
What
a,
is the effect?
you have to have a under the statute, under the Freeman case, you have to have a substantial effect on
What is that?
intrastate commerce. There's a conceded $2 to $4 million that is not going to be paid to someone in Tennessee because of this JUCO rule, and that's my client. That is substantial.
It's substantial as compared to what, though? To his, is that your class? Is that the class you're talking about, him, or are you talking about everybody in football?
It's the Freeman case as you look at the particular facts of the case, and this, I
Okay,
can't imagine a more
looking at the
compelling.
particular facts of the case, I'm trying to ascertain, one, what your class is and what the substantial effect is on our state.
Right. I believe that it's the Freeman case. If it's not, it's the other case that we cite on the substantial effects test in our reply that says you don't actually have to prove that the amount went down or any of that. It's about competition that has to go down.
And what shows me that competition went down?
They have removed a class of competitors from competing.
Is there any metric or any kind of calculation or any kind of solid proof that you can show this court that there was a difference?
On competition, yes, there's a class of players who can't play, and so they don't have to compete against each other on the teams
And that affect the state how, though?
because those players are in the state, and they're playing for the state schools.
Are they? Did you prove that?
Mr. Aguilar plays for the University of Tennessee.
He's the one person that you did prove. You didn't prove any of it.
Diego Pavia plays for Vanderbilt last
He
year.
does too.
Right. There are, I don't think it's contested, there are JUCO players in Tennessee that are on these teams, and that these schools are directly regulated.
What is the number of those people, and how does that substantially affect this state?
Your Honor, I just want to say, we're talking a lot about an argument that the NCAA doesn't make, but
I'm telling you that I have to write.
I understand
an
that.
opinion on this, and it's important to me to get it right, because I can't just make up numbers out of whole cloth. I have to have I have to have positive proof of something.
right,
And that positive proof would be, you've told me there's 2 people that the JUCO rule applies to, at least. Your client, Mr. Pavia. What other people, and how did those 2 people substantially affect commerce within the state of Tennessee? And how do they do it? And is that the class you want me to hitch this wagon to?
yeah, we would like Your Honor to say there's a substantial effect on intrastate commerce, because there are schools here and players here who are directly regulated. You have 2 of the highest paid athletes, college athletes in our state who are directly regulated by this rule. My client's being directly regulated right now to the tune of millions of dollars. And I think it's important to note, and I haven't said this yet, that in all the federal cases, a substantial effect on interstate commerce is also required as a proof of the claim. There is not a single court that has thought this was a problem for the JUCO rule, because it affects players on almost every team. I think it's our expert says it's 1 in 5 players who have former JUCO experience who are affected by this rule. I don't think when you take 1 out of 5 potential competitors out of a class of competition, that easily satisfies, I do think that easily satisfies a substantial effects test. If you look at the case law too, Your Honor, which I know you have and will again, the substantial effects cases say you don't have to do this in dollars and cents. It's about the effect on competition. And you can do that by quick look analysis. You can do that by looking at, sort of the primacy of the university involved and the player involved and the compensation involved. I think that's all easily satisfied, which I think is why they didn't challenge this element in this case. But we are not trying to shy away from the fact that there is a dearth of evidence on some issues. I think my friends sort of admitted what the NCAA's approach to this is, which is to win by default, to say there's this ticky-tack problem and this ticky-tack problem, and you're missing this evidence that we have and you don't, and you won't be able to get it, so let's go to trial. And when you go to trial, you'll have missed out on an entire season of college football, likely ending your career. I think my friend admitted that most of these cases just end after this phase. And it's an unfortunate sort of way we have to do it this way, but this is what temporary injunctions are for, when you have to go fast because someone is facing irreparable harm. And I just want to read, if I can, from the Gibson's treatise on this point. I think it's right on point.
What section?
49.26. It starts, in granting temporary relief by restraining orders or injunctions, courts of equity in no manner anticipate the ultimate determination of the question of right involved. It is merely recognized that a sufficient case has been made. And if you go to the next paragraph, I'm skipping some sentences, where the legal right is not sufficiently clear to enable a court of equity to form an opinion, it will generally be governed in deciding the application by considerations of the relative convenience and inconvenience which may result. Upon the balancing of such considerations, if it is apparent that the act complained of is likely to result in an irreparable injury to the plaintiff, the restraining order will be granted. And so I think Gibson's is contemplating this exact case.
What version are you looking at?
I think we have the 8th, Your Honor, but I'm not positive about that. But mine is 49.26 on page 49-17. And it's this exact case that Gibson is talking about, where someone has to bear the burden of uncertainty. I think Gibson says, and in a court of equity, this is a long-established principle, is not the party who's going to suffer irreparable harm every single day he's not on the field all the way up into trial. And my friend also said this is the end-all be-all. This type of hearing is the end-all be-all in these cases, and it is, because we have to act based on likelihoods, and we will go to discovery, we will go to trial. It's just about who has to bear the burden along the way. And I want to just finally address, just on the merits, just a light touch on the merits. Yes. The strategy about we don't know enough to grant relief, it's not that this data doesn't exist, or you'll never get it, or that you're even wrong about these economic calculations. It's always, well, you didn't say enough about the market, or you didn't have enough of the data. We don't have it, the expert doesn't have any data either. He uses the basic economic theories that we do. And it's these ticky-tack criticisms. I was going to zoom out a little bit. We're talking about the definition of a market to assess whether something is anti-competitive, and has anti-competitive effects. The Maurice Claret case that we cite in our brief says market definition is not the end-all be-all, it's a tool. It's a tool to help you determine whether an actor in a space has the ability to have anti-competitive effects. We're talking about the NCAA in this case. If you're talking about college football, they're the only game in town. They have a complete and absolute monopoly. This is not where your two firms of doctors get together and start excluding patients, and you're like, I don't really know if they have enough to affect the market in this area. This is the market, and they have complete control over it. You have to be a member of the NCAA. You have to abide by their rules. It's not hard to determine their market power. And so what the federal courts that have gone our way have said is this is the situation where you can apply a quick look, especially on a temporary injunction. You've got a conceded monopolist who is excluding a class of competitors from having to compete, and from competing against the existing players. And the reason, the NCAA concedes the reason, this is what Judge Hermendorfer says in the appellate opinion in Pavia, the conceded reason is to swap out more experienced players with less experienced players. That, again, that sounds nice, but when you're doing antitrust law, that is blatantly illegal and anti-competitive. And it's not It's not academic. I think my friend doesn't have any answer to my coaches hypothetical. If you were doing this with coaches, no court, I think, would be demanding serious data. It would just be taken on a quick look that is obviously depressing the salaries of coaches. And it's not academic because there's a real client here, a real example with real data that he is going to lose $2 to $4 million in immediate NIL compensation. And it is not contested that that will not go to another player. They've talked about a salary cap. The salary cap doesn't apply to third-party NIL. That's where most of the money is. And that's not a secondary effect. You get third-party NIL in conjunction. You work together with your school. It's in conjunction with your total package that you get as a player. It's for playing. Everyone understands this. I think the NCAA likes to pretend that it's not, but that's the reality of what's happening. Adidas is giving third-party NIL to Tennessee players. It is part of the package. And so when you don't let the more experienced, the inspiring, the SEC passing leader from last year, if you're excluding that person from the market, you're losing out on that money, and it's not going anywhere else. And the last thing I'll say, of course, I want to answer any questions Your Honor has that's remaining, is just I think the Commerce Clause argument petered out a little bit, but one thing I wanted to mention, because I just remembered it, is TCA 29-14-107. I heard my friend make a pretty serious challenge that the constitutionality of Tennessee's antitrust law. And if that's happening, that they have a duty to notify the Tennessee Attorney General, because he's not a party to this case. And so I don't think the Tennessee Attorney General would agree that its antitrust law that the legislature just passed 2 years ago is unconstitutional. But one way to not have to deal with any of those problems is to say, I will assume that Tennessee's law, for purposes of this case, I'll take their position, which is that it's no broader than federal law. If it's no broader than federal law and they're violating federal law, there's no constitutional problem because the conduct would be illegal. There's no conflict between state and federal law. And so Your Honor could take that approach because I think, again, the persuasive cases, 4 of them have gone our way on this. Pavia, who Vanderbilt agreed to the rules, but Pavia played the entire season and was the runner-up for the Heisman Trophy. Moore, my friend says that case is ongoing. That case is dead. Moore is declared for the NFL draft. There's nothing else to litigate. He got to play at Indiana as the starting safety and win a national championship because the JUCO rule was determined to be, on a quick look, preliminary injunction, anti-competitive. Thank you.
You don't have to take my word for it that this is not enough. Every appellate court that's had the occasion to address this issue and rule on the merits has said this record is insufficient. It's just what it is. It is insufficient. If we're going to suggest that the NCAA is some sort of entity that has not been heavily scrutinized by the court and that there's not some guiding principles out there that apply to these, that's wrong too. The Alston case that gets so frequently talked about here in this context about how it was the death knell for the NCAA. If you read that case, it is narrow. It applied to education-related benefits that were at issue there. But the opinion that Justice Gorsuch wrote, along with the concurring opinion that Justice Kavanaugh wrote, give this court guiding tenets. Caution is key. When markets are changing, like the NIL market is, so does the legal analysis. Judges must know their limitations as economists and to measure small deviations in complex business arrangements is not an antitrust function. It's not the point. You don't make small changes to complex business entities. You don't know the outcomes of them. And until you know the outcome, you don't pull the lever. Until we know what's going to happen. It takes time. The Supreme Court was effusive in its praise for the district judge in the Alston case because she did not jump at the starting line. She took years of discovery, had a 10-day bench trial, and issued an order that said some NCAA rules violate the Sherman Act, others don't. But we know now. We know which ones do and don't, and that's the ones that we're going to enjoin going forward. Caution was key. You do not make knee-jerk decisions. And we know that every appellate court that has looked at these issues and when somebody has been granted an eligibility injunction, has been struck down, overturned if it's on the merits. The suggestion that the burden should be, the burden to Mr. Aguilar, he shouldn't have to bear that. That's effectively saying that Furman, Georgia Tech, Kennesaw State, Texas, Auburn, Arkansas, Alabama, South Carolina, Kentucky, Texas A&M, LSU, and Vanderbilt should bear that burden. They should play against somebody who is not eligible under the rules they've agreed to abide by.
That's our schedule.
That's your schedule, plus a bowl game, I hope, or a couple college football playoff games. But that's who has to bear the burden then. It goes back to what I said. We don't have to do this. We can say that this is not how the law in Tennessee works. And we can say it, and we can still say Mr. Aguilar is a great story. He's a great college football story. But the great thing about stories are you don't have to read the same one again. You get a new one. That's what we like about stories. We got the Joey Aguilar story. Who's the next story? I don't know, but I hope it's a good one. And we're not going to get it, though, if we don't say we follow the rules. And for those reasons, if you don't have any questions, Your Honor, I restate my request that the injunction be denied, and I appreciate your time this afternoon.
Gentlemen, I appreciate the zeal and the fervor that you have for your side. Mr. Aguilar, I really appreciate everything you've done since you've come to this state. These issues are far-reaching. I know this is just a Tennessee court, but it's my court, and I'm not going to get it wrong, hopefully. There's been questions brought up. Like I said, I got 1,200 pages of documents from yesterday. Mr. Maxey's testimony, I'm going to have to read every bit of it. That's going to take a while, but it's not going to take too long of a while. I know that he has, Mr. Aguilar's time constraints on him. I can't rule from the bench on this, particularly when the Tennessee statute is involved. I took great care to either one, analyze the statute in a way that I can keep it constitutional, or analyze it in such a way as to do substantial justice. I appreciate what you've done here today. Thank you very much. You should have my opinion in very short order. Do we have any, if y'all would approach your procedural questions, I'm going to extend the TRO until the opinion is issued. But any other procedural questions if you have to come forward? We're adjourned.
All right, please. Thank you. Adjourned. Thank you very much. Sarah, thank you.
Thank you. I'm gonna go back down and see if they're still in. Oh, no. You need to transfer. Not yet. Okay. Yeah, I'll have to go back down there and see if they're still.
Will you tell Judge, will you tell Judge Harrington thank you?
Yes.
It was actually,
It was me, Miller.
And tell Greg thank you.
Yeah, I will.
You guys get it, Mr. Aguilar?
I'm told yes, unclear. It's, the day is young. Yeah, well, I mean, you did.
hey, James Norman said that you have a.
Oh,
James this week. In this.
Oh, really?
Yeah.
How's he doing?
He's one.
Well, we all.
said that, you have.
It's great to see you, though.
Well, do you care to go down to
Yeah.
the zip or sit down there?
That was it. I could not put it there. Yep.